Welcome to this new episode of Terms of Engagement, and thank you all for the incredible attention that you all have been paying to this series. Power is being centralized all over the world, and certainly in India. I do not think anyone disagrees with that observation. Some consider this centralization of power effectively in the executive a helpful instrument for national progress. Some others consider this a harmful turn that can weaken our democracy. Our guest in this episode of Terms of Engagement is Gautam Bhatia, lawyer and constitutional scholar, whose most recent book is titled Indian Constitution, A Conversation with Power. The key argument in this book is that there has been a centralizing drift in India's journey as a republic. How much of that is due to the original design of our constitution? How much of this centralization is due to the legislative measures? And how much is due to judicial interpretations and interventions? Are there any countervailing forces at play? And most importantly, are we on an irreversible path of ever-increasing centralization of power and weakening of distribution of power vertically and horizontally? These are some of the questions that we will discuss with Gautam in this episode. And thanks Gautam Bhatia for finding time and joining me today for this episode of Terms of Engagement.
Thank you for inviting me.
Right, okay, so let us start with what you discuss as the organization of power. Who wields it and how is it distributed within the society? I think the book is entirely constructed around that concept. Could you begin at that concept first?
Yeah, so constitutions normally have two parts. One is what we call the programmatic part, which is the bills of rights, declarations of rights, these statements of principle. But the other is what some scholars call the engine room of the constitution, which is the part that basically determines the structure of the state and the questions around how is power organized, which bodies or institutions wield power, how is power constrained. So effectively looking at the constitution as a map of power and the constitutional terrain as a terrain of contestation between different visions of power that take place, through interpreting the constitution, through court cases and judgments, through debates outside the courtrooms, all of that. So that is effectively the approach to the constitution that the book undertakes.
So one is the dogmatic aspect of it. You have a rhetorical understanding of what it should be, and the other is, as you point out, an organic manner in which power actually plays out between different interest groups and actors within the system?
Yeah.
That's what it is. All right. Okay, so you also sort of review and give a summary of the book in the book of three established ways of looking at the Constitution. One is Indian Constitution as a colonial legacy. The second one, it is a very transformative and transformational framework for organizing ourselves. And then the most important argument, which I personally would go with, that it is an inconclusive document. You are only actually giving a whole lot of options and leaving it open in a very long text. So can you just summarize for our viewers what are the three ways of traditional ways of looking at or analyzing Indian Constitution?
Yeah, one understanding is that it's a document of colonial continuity. So when people say that 75% of the constitutional text is directly borrowed from the 1935 Government of India Act, when people say that many of the colonial instruments of oppression like a detention without trial or the ordinance making power also can be found in the constitution, the argument is that effectively the moment of constitutional framing was just a moment of transfer of power from the departing British regime to the new Indian regime, but nothing really fundamentally changed in terms of the way the constitution operates or the way the constitutional document operates. That is one account. The other account is that actually the constitution was meant to be fundamentally transformative, both in the political sense and in a deeper social sense. So, for example, by giving universal adult suffrage at one fell stroke, effectively the constitution transformed the Indian people from subjects to citizens. Similarly, through the extensive Bill of Rights, through provisions like abolishing untouchability, non-discriminatory access to hotels, wells, places of public resort, minority rights, religious freedom, all of that. It was also meant to transform society and interrogate hierarchical power structures that exist outside the state and in society. So that's the second approach, and again, different accounts. Some people argue that the Supreme Court, through its expansive reading of the Constitution after 1980, has implemented the transformative vision. Some people argue that it's not yet happened because, in other respects, the court has been deferential or in favor of the state power. But the accounts agree that the document is essentially meant to be transformative. So that's the second approach. And the third is that actually there is no unifying, coherent vision underlying the constitutional text. It was the product of a political compromise. The Constitutional Assembly was bitterly divided over a range of crucial issues. For example, language, the place of religion, the structure of the state, and so on. So finally, what you get is a compromise document, which is relatively, it's a terrain of contestation, and there's no dominant vision that you can see, which is clear either way. So these are the three broad approaches to understanding the Indian Constitution.
While you are very careful in avoiding a judgment on any of those three, at this point, if I may push you to make a preference of which of these arguments do you think would be the most appealing to you as a scholar of Constitution?
So in the book, I argue that all three. I mean, the mistake they make is that there is too great a focus on the fundamental rights chapter. So when you refer to constitutional identity, when you refer to the constitutional character, either way, for any of the arguments, ultimately it becomes about really a strong focus on what the fundamental rights say, their restrictions, and so on. I think that's a mistake. I think you have to pay equal attention to the way the Constitution organizes power and the power map. And there, I think that the conclusion that I draw towards the end of the book is that in many respects, the Constitution left the colonial power map untouched. In fact, it contributed to, in some ways, entrenching that power map in broadly, by design, favoring a more centralized, homogeneous, statist, non-distributed vision of power over a more decentralized, democratic, distributed vision of power. But with that said, this is not, something that is set in stone. So even though the text suggests a certain vision of power, even though courts have often interpreted the Constitution in consonance with that centralizing vision, like all documents, like all human artifacts, the Constitution is not dispositive of meaning. So constitutional meaning is always a struggle, it's always contested. And so what I argue is that historically there have been attempts to also read the Constitution against the grain and to, in a certain way, attempt to advance upon the constitutional terrain a more democratic and decentralized vision of power as well.
Right. All right. Okay. So you reach the conclusion that so far the journey has been of one of centralizing drift, and you are actually citing 6 different strands and elaborating on those 6 different strands to actually arrive at that conclusion. We will take those 6 strands one by one, and maybe we will spend 1 or 2 minutes each on each of those arguments, and then we will come to that conclusion. The first is federal versus unitary. That's a binary, and what is the concept and how has it evolved, and where do we stand on that question right now? Federal versus unitary.
So formally, India is a federation in that you have 2 levels of government. Now, of course, we have 3 with the Panchayati Raj, but that is significantly under the control of the state. So it's not really an independent third level. We have 2 levels of government, the center and the states. The Constitution by design is imbalanced or skewed towards the center through various provisions. There are reasons for that we can go into, if you want to. And in the argument in the book is that the Supreme Court, when faced with a choice between 2 visions of interpreting the Constitution, a centralizing vision and a federalizing vision, has tended to choose the centralizing vision, by which I mean that where there is a constitutional ambiguity or a silence in the Constitution with respect to who should hold power, the court has interpreted that silence or that ambiguity in favor of central power and against state power. That has been more or less the consistent trend of the court from the beginning, with a few exceptions.
Would you argue that the idea of the tilt towards centralization is an original intent in the constitution itself, the original, the others, because
yes, it is. If you look at the constitutional text, that is clearly the design of the constitution is meant to skew power towards the center. But that does not exhaust the question of what do you do when there is no clear mandate in the constitution, or when there is an ambiguity and there is a center-state dispute. How do you resolve the ambiguity? So the original constitutional tilt towards the center does not exhaust that question of what to do when there is an ambiguity. And there the courts have stepped in and often interpreted ambiguity in favor of the center, which entrenches further the centralizing drift.
So the second strand of centralization is the two opposing forces. One is the idea of concentrated power and distributory power, as in like between the executive, judiciary, and other branches. So there again, we see that concentration is actually the direction of between those two binaries as well. Could you explain that?
Yeah, this is perhaps where the constitutional design is most explicit, because so India is again formally a parliamentary system, and parliamentary systems normally have been seen to have a drift towards executive power over time. In India, this drift is even more pronounced because through, for example, mechanisms like the 10th schedule, which are anti-defection, so they prohibit defection, but then what they also prohibit is they prohibit any kind of intra-party dissent in parliament. So that gives the party leadership, which in the cases of the ruling party will also be the effectively the cabinet and the prime minister, overwhelming power over their internal party structure. So in parliament you can't really have dissent against the ruling party. There are certain complications as to why that's the case, which I go into in the book, and we need not go into it here unless we need to later on. And also, so that is the internal check which is missing. But there's also the external check or external ways in which parliament as an institution can often check and constrain the executive, which is also compromised in India primarily because parliament acts through the speaker. The speaker is the representative of parliament to the executive, which is why the speaker being an independent person is crucial, because so many decisions, for example, decisions regarding prime minister, questions to the ruling party regarding this, other kinds of activities in parliament are within the discretion of the speaker. The Indian constitution does not guarantee the independence of the speaker. In fact, the speaker is from the ruling party because that's how the votes stack up. And we've seen a history of speakers who act in partisan ways, which is not to do with individual persons, but that the constitutional design incentivizes partisanship in the speaker's office. And thirdly, of the upper house. The upper house is also supposed to be a check on the lower house. And often the upper house's composition might be different, which again creates this horizontal check. Here again, the problem is that through strategies like, for example, the speaker certifying bills as money bills, which then prohibit upper house from exercising vetoes, effectively renders that oversight very weak. And also, the chairperson of the upper house is the vice president, who again will in most cases end up being somebody selected by whoever the party is in power. So in that way, which is again the executive. So in that way, we see that many of the classic institutional features that in parliamentary systems would allow parliament as a body to exercise oversight and checks upon the executive are either non-existent in India or have been diluted. And that's again why we see a gradual shift in meaningful power, even legislative power, over the years to the executive and not to parliament where it's meant to belong.
Also, I think the sheer reduction in the number of sittings that state assemblies and parliament have nowadays.
Well, so that's the thing, right? So that's not something that happens independently. I mean, if parliamentary work has no meaning, no genuine meaning, and if parliamentarians, both at centre and the state, see their primary task as basically tending to their constituency and doing work in the constituency and not representing the constituency in parliament, because representation in parliament basically has lost meaning, then there is no reason why parliament or state assemblies will sit, because what do you do? So again, it's important to link what we see happening around us to the constitutional design and structure, which creates certain pathways and blocks other pathways.
Right. Okay. The third argument is between the contrasting forces or arguments of homogeneity and plurality. So here again, we have over the decades shifted more towards the idea of homogeneity. And do you think, of course, it has happened, and why it has happened? And do you also see that as a political society, there is a kind of agreement with the idea that pluralism or diversity is not really the most desirable path to progress and national consolidation?
So the book refers to pluralism in a specific context, which is to say that in any diverse plural society, linguistically, ethnically, racially, or politically diverse society, the federal arrangements will reflect that. So different federal units based upon these considerations will have different relationships with the center. So classic example being Quebec in Canada, the French-speaking francophone majority province in an English-speaking country, so you have a special arrangement. And in India, you see that reflected in Article 371, where many of the northeastern states have specific arrangements with the center involving vetoes over certain kinds of laws, for example, other things, other kinds of administrative, special arrangements of various states. And of course, you had Article 370 until 2019, which had, of course, been effectively hollowed out over the years, but existed in a formal avatar until 2019. Now, the argument I make in the book is, and also 6 schedule areas, where Adivasis live, certain arrangements over there. Now, the argument I make in the book is that if you look at the history of the framing of the Constitution, none of these special arrangements were actually provided for as a matter of principle. So there was no principled agreement that, the diversity of India should be reflected in the diversity of these arrangements. These were all political compromises. Kashmir was a geopolitical, compromise, and even the 6 schedule areas came about as a result of compromise and of just the idea that there needs to be some protection for Adivasis without letting them actually have meaningful autonomy in self-governance. And even northeastern states, Nagaland, Mizoram, and so on, these provisions come into being effectively because there is violence and the state needs to hold on to these territories, and so the only way to do it is to compromise and give them some autonomy in exchange for not pressing ahead with the secessionist war, right? So that's sort of what happens in Nagaland specifically. The Naga special arrangement is a compromise to bring to an end what is effectively an armed struggle for an independent Naga state. And so basically, the Constitution is very uneasy with this idea of there being diverse plural arrangements. The Constitution by design seems to prefer a much more homogeneous nation state, and that is reflected, of course, in court judgments, most notably and most recently in Article 370, where the entire basis of the court's judgment was the idea that the end goal of Article 370 was the integration of Kashmir, and by integration they meant a homogeneous arrangement, much like other states, which of course is the assumption. That's not specific there, but that's what happened.
So even when we are pushing for a more homogeneous way of organizing society in this particular aspect, we still see some attempts to actually being accommodative of pluralism or plurality, as the case may be. For, let us say, uniform civil code. While from within that argument for a uniform civil code, you still do have a carve out for tribal communities. So on the one hand,
well, but that does not follow from any, as I say, principled idea that there should be pluralism. That is obviously follows from a no. So like I said, if you look at the history of the Indian constitutionalism, where in the Constitution there exist plural arrangements, they are the result of effectively a situation where a concession had to be made in order to quell a more serious uprising or more serious dissent. So, for example, the Naga special status literally exists because there was a civil war going on, and this was, this federal sort of arrangement was an attempt to try and placate the people who did not want to be a part of India. Similarly, Article 370 exists not because the framers were great believers in pluralism and the fact that Kashmir should have its own constitution. It's not that they believed in the principle of that. It was taken from them on the threat of actually the Indian Union, not having Kashmir as a part of it. So actually, it fits perfectly well, because the argument I make is that that wherever there do exist these pockets of diversity or pluralism in the constitution, it's because the union was forced to give in, and not because there was a principled belief in the merits of pluralism and diversity.
Right. The fourth point is between electoral and guarantor processes that we have. One is, of course, electoral, and the guarantor institutions are what you term as are institutions like the Election Commission of India or the CAG, and those were actually to act, though they as checks on absolute power or concentration of power, but they've not been able to. Though we have had in the interim occasions to think that, okay, these are institutions that are actually doing exceptionally well, not merely in keeping their own integrity, but also providing some new framework for understanding or reorganizing power. Yeah. Let us say the Election Commission under T.N. Sheshan and one phase of CAG, which in hindsight actually raises a lot of question, but at least appeared to be so. How do you see that thing? How did you explain those phases of sudden assertion of these institutions, and then we are in a situation where they are actually facing a major crisis of credibility?
So I think that history actually shows you that there is no firm entrenchment of these institutions in the constitution. So if you look at the way the constitution is structured, in the original constitution, both the CAG's office and the election commission, the appointments were by the president, which effectively is by the executive. They were under the control of the executive, and in the election commission goes, the idea was that parliament will pass a law. Parliament never did until a year ago, which again is a whole different story. And so this was a constitution that is what I call an executive trusting constitution. It did not believe in guaranteeing or entrenching the independence of what we call fourth branch institutions like election commissions, CAGs, other bodies, information commission, again a product of statute, human rights commission, again a product of statute, and so on. And so what then that does is that it allows for the executive, if it so desires, to exercise control over these institutions and bodies through the power of appointment, the power of tenure, and so on. Now it so happens that certain times the executive can lose control, which is what you see in the Session era, in the CAG era. But ultimately that is not because the constitution guarantees the independence or secures the independence of these bodies, but because there are political phases where political power weakens at the center, other bodies come in, and so on. That's more a function of politics than the function of constitutional design. And in fact, the present credibility crisis of all these institutions shows you the problems when the constitution effectively gives this power to the executive, in fact, to exercise kind of control over these institutions through appointing power and so on.
Right. It's okay. And we'll come to the fifth point now, which is about the power that the state has vis-a-vis the power that people as a collective, the sovereign, has. How do we make the distinction, and how do we understand the concentration of power in the state and drifting away from the people as a distributed source of power?
So are you referring to the rights chapter or the role of the people in the constitutional scheme chapter? Because both of them deal with the people in different ways.
No, I think your the fifth argument, that the fifth strand in the
constitution is on the right, is on rights. Yeah.
State versus the people. How state becomes more powerful as opposed to the people, where the duties are more emphasized and rights actually gets
yeah, so this is where we look at the fundamental rights chapter. We look at the fundamental rights chapter as an attempt to rebalance some power between the state and the individual, because rights effectively serve as a shield for the individual. They create a no-go zone beyond which the state cannot go. And what we see if we look at the rights provisions in the Indian Constitution, and I consider here the rights meant to protect the individual in a core way, the individual's liberty, life, and body from and the encroachment of the state. So articles 20, 21, 22 of the Constitution that really are meant to protect the individual's personal sanctity from being violated by the state. And what you see here is that the way these provisions are framed, they are meant to serve less as walls or as shields, but more as actually facilitating certain kinds of state power over the individual in the criminal law context, and they retain a lot of the structure of the old British, system. The classic example is, of course, the retention without trial in the Constitution, Article 22. India is one of the perhaps only constitutions that specifically sanctifies a detention without trial in the constitutional text. And then the courts have contributed to this, and the courts have what they've done is, and I deal with this in the book, they have systematically, through interpretation, limited both to whom these provisions apply, by, for example, reading narrowly the word accused, and thereby excluding a range of people from these protections under the Constitution, and also by expanding the kinds of legal proceedings that are exempted from complying with these constitutional principles, which is why, for example, recent controversy when the ED acts, often the ED is not bound by respecting or bound to respect the obligation against self-incrimination under the Constitution. So, and there are long reasons for that, which we can go into. But basically, the courts have taken these provisions and they have narrowed to whom they apply to, and broadened the exemptions for the state. And so this pincer movement then has really weakened that shield that rights are meant to present against the state.
Right. And the final and the sixth point that you make is the tension between the representative form of power and the direct exercise of power by the population as a whole. What is the concept and how has that evolved, that dynamic evolved?
So the Constitution begins with the phrase "we the people," and that's true for most modern constitutions. The question is that after you say "we the people," what role do the people have in the constitutional scheme after that? And there we see that actually the Constitution is completely silent about the role of the people after the preamble. In the only role the people seem to have in the Constitution or in constitutional governance is that once in 5 years you vote, for the center, for the state, as the case may be. So you vote in elections, but between elections there is no role the people have participating in constitutional governance and so on. So, for example, the amendment of the Constitution does not, in any way involve the people, unlike many other countries. There is no guarantee of public participation in lawmaking, which you find in a lot of modern constitutions like South Africa and Kenya. And there is no requirement of public participation when it comes to executive action that could impact a large number of people, as in big environmental projects, big business projects, which displace many people. If you look at Latin American constitutions, there they have all these guarantees of public participation in these kinds of executive, actions. So whether you look at the constitutional change, legislative action, or executive action, the Constitution does not have a role for the people to act outside of elections in all that goes on. So that is how the Constitution, in a certain sense, divides power in that domain. It really is committed to almost a pure representation model with no elements of direct participation of the people in constitutional governance.
In fact, even the very idea of referendum perhaps attained some kind of notoriety in Indian context because of its association with Kashmir and its evolution of Indian policy vis-a-vis Kashmir. Would you agree? Because nobody.
Well, the referendum is just one method. You have the right of recall in, for example, many U.S. state constitutions, the right to instruct in certain cases. Yeah, so referendum is an instance of participation of the people in constitutional change. There are many other ways that it can happen as well.
Right. All right. Okay. So based on the last 30 minutes of what we've spoken, I think the 3 points that I will just flag before we wrap this up. One is that we discussed both judicial interpretation as actually driving more and more centralization over the years, And then also the fact that you alluded to, a lot of these outcomes are fundamentally political, because the way things have changed, the source of that changes are actually political in nature. So therefore, how insulated or how susceptible is judiciary to public opinion if you look at the pattern of Indian constitutional evolution?
I think it is the case as it is for any other country, which is that the judiciary will might be 10 degrees to the left or the right of public opinion, or what it perceives to be public opinion on any given topic. It is almost never going to go beyond that on either side. And that's true for all the big cases that you've seen, and so I think in that way the Indian courts are not different from any other court anywhere else. And I think it's worth remembering that judges come from society, and they reflect society in its best and its worst avatars as well. So you're not going to have a judiciary that is in some way radically different from the society that it comes from.
Also the possibility of a judiciary or a judiciary as an institution which is radically opposed to public opinion. When we make that argument that institutions as a bulwark against populism or popular opinion, that only takes us to a limited extent, only so far, right?
That is the history of every country. Your institutions can, up to a point, facilitate or impede the way power is exercised, but they cannot substitute for the exercise of power. So after a certain point, the institutions will bend in the direction in which power is flowing, and that's something that's again true for every country everywhere.
Okay. So you discuss in the book an emerging.
But I mean, the question, in the book at least, I mean, the question is that the argument in the book is that what the Constitution does is that it makes certain kinds of political power easier to exercise and certain kinds harder. Right? So the Constitution facilitates a kind of centralizing, and it impedes a more federal politics. So that's the argument in the book, right? The Constitution shapes and it informs politics, but it doesn't obviously substitute for politics. It can't. It is the terrain on which politics happens, basically.
Right, absolutely. So you also conclude towards in your arguments, towards the end of the arguments, that there is a constitutional common sense that is emerging as an outcome of this, and that common sense actually makes it impossible and even outlandish it would to make certain kinds of arguments which may be rationally permissible within the text of the Constitution, but that becomes impossible to be presented in an open court. And that I found it very fascinating. Could you just illustrate that point with some examples?
Yeah, I mean, the idea of constitutional common sense is what other scholars call constitutional culture or constitutional convention. In some cases, a little different, but the idea is the same, which is that, as with any practice, there are certain internal rules which you will not see spelt out anywhere, but those who are internal to the practice, know of them as the rules that govern their conduct. And so that is so constitutional common sense or constitutional culture is that, okay, there are certain arguments that you can make and certain arguments you can't make. I'll give you an example of my personal experience, which is my involvement in the Article 370 case, where one issue was with respect to the relationship between the Jammu and Kashmir state constitution and the Indian constitution. Now, in federal structures, the idea of a state constitution is very, very common. There is nothing outlandish about it. And the idea that the state constitution in a federal system occupies an equal status to the federal constitution in certain relevant respects, and has its own existence independent of the federal constitution, is also a very, very well established principle. The US and many other countries, right? But when the issue arose in the Indian context about the relationship between the Jammu and Kashmir state constitution and the Indian constitution, it was evident that any argument to the effect that these are two complementary documents and there is no hierarchy between them simply could not be made. and the premise had to be that the Jammu and Kashmir state constitution occupies a legally subordinate place to the Indian constitution. Now, there is nothing in the text that requires that. There is nothing in either of the two texts of the two constitutions that mandates that, or even suggests that. But this is constitutional common sense, in that when you're a lawyer or a judge or a person in the courtroom engaging with the case, that certain arguments that you cannot make because they will not be taken seriously. And this is, again, it's across cases, across times, and this is just one example. But there are many other examples where effectively a large part of constitutional adjudication and the shaping of the constitutional domain happens through constitutional common sense, and not in any explicit or formal way.
So, Gautam, thank you for joining us in this episode. And this is my final question to wrap this up. So, the centralization is considered necessary by not only its practitioners, but also many people. Scholars do argue, even from the original makers of it, the centralization as an instrument to ensure rights. Now, it is not really an accident that even the Article 370 measure, or a lot of these things, are defended on that premise. Like, for example, what happens to the Dalits of Kashmir, or for the women among the Muslims. For all these measures to ensure that everybody's rights are advanced, you have to have a more concentrated system of power. And secondly, they also argue, generally people who are in favor of centralization, that for progress and efficiency, more and more centralized forms of exercise of power is necessary. How do you view that, and if you have a counter argument to that, what that could be?
I think history is a counter argument, because I don't think that centralization has actually served to protect rights in a better way. I think that the evidence for that is already before us, and nor has it necessarily led to greater efficiency. So I think the historical verdict so far in 75 years is that at least for these two goals, centralization has not served the purpose. Now, I think the argument people will make is that what it has done is it has kept the country together, right? So you need to have centralized power to for example, engage with insurgent movements, or movements that in some way wish to separate from the state. And of course, that is the point of centralization. It is to enable central control, over what the center thinks of as peripheries, right? So that might be one argument that people make, and that has its own place. But I think that at least as far as the rights protecting argument goes, and as far as the efficiency argument goes, I think that historically there's been it's not really worked out. Of course, we don't have a counterfactual, so we don't know what it would have looked like, had there been greater democratization or decentralization or dispersal of power. And so in my penultimate chapter, I discuss, in a chapter called Yesterday's Tomorrow, I discuss various other visions that were present at various points in the historical trajectory, that actually imagined a different power. In the 1920s, many of the princely states, they drafted constitutional documents that envisioned a radical dispersal of power. At independence, you had a Gandhian, model draft constitution, M.N. Roy's humanist constitution, and so on, that again imagined a much more dispersed kind of power. And after the emergency was lifted and Indira Gandhi was defeated, there was an attempt to undo much of the centralizing character of her constitutional changes, which I argue went halfway through and didn't go any further. But I have given these various historical examples to show that the centralizing vision has not been the only vision, and people have thought of other dispersed visions where again you would have provisions for protecting rights and so on. So in that sense, it's not that the rights protection or efficiency is incompatible with dispersal of power, as long as there is a careful thought being paid to questions of design, structure, and so on.
Thank you, Gautam Bhatia, for this very fascinating conversation on how power is designed and exercised in Indian system, Indian political system, Indian society, and how it is evolving. Thank you for finding time and joining us.
Thank you so much. Thank you.